Welcome back. Today we will be dealing with the topic that is Constitution Emergencies. Recall that Constitution of India is a very elaborate document which speaks about division of powers between center and state. Some of the constitutional experts and jurists have already cited Indian Constitution as the one with the strong centralizing tendency. Though in essence it is federal constitution, but sometimes the operation of the constitution becomes unitary for the greater good of the public. So the constitution comes across certain unforeseen circumstances which are dealt as emergencies. So in the day-to-day functioning of the democracy, we will see that there may come certain circumstances or stages where the regular functioning of the government in accordance with the rules and regulations established may not happen so. So in that particular situation where the circumstances or unforeseen circumstances are there, in that particular situation, how the constitution tells the state to function, that we will see. So it is covered under the wide term of emergencies. So the Constitution of India contains provisions pertaining to the emergencies under Part 18 of the Constitution, that is Articles 352 to 360 of the Constitution of India deals with the aspects of emergencies. And it speaks about three kinds of emergencies. So here we will see that the Constitution of India gives elaborate provisions pertaining to the emergencies under Articles 352 to 360, which speak about three emergencies, namely the national emergency, that is constitutional, and next one is constitutional emergency or president's rule, and the third one is the financial emergency. So we will see that the emergency powers are meant to ensure that the democracy returns to its normal. So these provisions are to be used in exceptional circumstances. So the provisions pertaining to the emergencies have been borrowed from various constitutions by the constitution makers. As we have already seen that Indian Constitution contains all the best features borrowed from the other constitutions of the world. So here also some of the provisions pertaining to the emergency we have borrowed from the various constitutions existing around the world. Now we will see what are the three kinds of emergencies as envisaged by the Constitution of India under Articles 352 to 360 under Part 18. Now first we will see the national emergency given under Article 352 of the Constitution. National emergency under Article 352 of the Constitution. So India is a newly independent country in the year 1947, and it has to develop its country, develop its economy to ensure that the ideals as laid down under the Constitution are clearly laid down. The Constitution was enforced in the year 1950. From 50 onwards, the journey of this democracy has started. However, it was interrupted by unforeseen circumstances like war and external aggression. So in that particular situation, how the government of India should function? First and foremost thing is the national emergency. National emergency under Article 352 speaks about a circumstance where entire India or a part of India has been threatened by war, external aggression or armed rebellion. War, as we know, is the hostilities between the two nations, and we see armed conflict between two nations. So during that particular period of time, it may not so prudent for the state, that is the government of India, to carry on with the regular provisions of the Constitution. Why? Because the first strategy when there is a war pertains to the defense of the motherland. So during that particular period, the national emergency can be imposed. Next one is the ground of external aggression. So external aggression need not be a war. It may be some kind of insurgency by the enemy countries or hostile countries upon the territory of India. So it can be external aggression or armed rebellion. Armed rebellion happens where there is a civil war kind of situation whereby the ordinary citizens, they take up the arms against the state. So, on these three grounds, that is war, external aggression or armed rebellion, are included as grounds for imposition of national emergency under Article 352. However, prior to the introduction of the word armed rebellion under this particular article, there used to be another ground known as internal disturbance. Now, when we speak about the internal disturbance, we will see that this ground was very vague and it can be misused also. So, that is what the situation which has happened in 70s. So, that was imposed on the ground of internal disturbance. So, on the ground of external aggression and war, in 1960s during the Indo-China war, the emergency was imposed. Then we will see the procedure. Now, emergency cannot be declared overnight as such. There are certain procedures laid down under the Constitution of India itself which say or which lay down the method in which the emergencies can be imposed, that is the national emergency can be imposed. The Constitution specifically uses the expression proclamation of emergency. So, wherever the word proclamation of emergency is mentioned, it means the national emergency under Article 352. So, it will be proclaimed by the President of India. Now, the question is, can the President of India do so independently? The answer is no. The President of India has to act upon the advice as tendered by the Council of Ministers. And in the case of imposition of national emergency, the President of India can proclaim national emergency only upon the written advice as given by the Council of Ministers. So, written advice was included as one of the essentials for imposition of national emergency in the 44th Constitutional Amendment. Then, mere imposition of national emergency is not enough. Why? Because you should have the parliamentary approval. The executive, that is the President of India, should have the parliamentary approval for continuation of emergency. That is, within 1 month of imposition of national emergency, it has to be placed before the Parliament. So, once it has been placed before the Parliament and the Parliament through special majority, that is 2/3 of the members present and voting, pass the resolution in continuation of emergency, then it will remain alive for a period of 6 months at a time, and it can be extended for 6 months at a time indefinitely. So, here we have to see that the Parliament also plays a crucial role when it comes to the continuation of emergency. For instance, if the President has proclaimed national emergency today, it will continue for a period of 1 month. Within that 1 month, he has to place that resolution before the Parliament, and if through special majority the Parliament passes that particular resolution, then that particular emergency will continue for a period of 6 months. And if you want to increase that period, again you have to put forth before the Parliament, and after the parliamentary approval, it will continue for a further period of 6 months. So, like this, for 6 months together, it can be extended indefinitely. So, that is what the national emergency under Articles 352 says. So, it can be imposed on the ground of war, external aggression or armed rebellion, and the procedure laid down is proclamation should be made by President only upon the written advice as given by the Council of Ministers, and the duration is within 1 month it has to be placed before the Parliament, and once the Parliament approves through special majority, it will continue for a period of 6 months at once, and if you want to extend it again, then again it has to be put forth before the House, and it continues, it can be continued indefinitely till the circumstances come back into the picture. Now, we will see what are the effects of national emergency. The first and foremost impact is the impact on the fundamental rights. So, in an ordinary circumstance or during the normal circumstances, etc., peaceful circumstances, it may be easy for the state to ensure that the citizens are enjoying their fundamental rights. But during the case of national emergency, where the country itself is threatened, where the national security itself is threatened, during that particular circumstances, it may not be possible for the state to protect the rights of all the citizens. The first and foremost aim of the state would be for the protection of sovereignty and territorial integrity of the nation. So, in that particular spirit, some of the fundamental rights can be suspended. So, here impact on the fundamental rights, if we see, Article 359 says that the President, when the emergency has been proclaimed, that is the national emergency has been proclaimed under Article 352, he can suspend all the fundamental rights except Articles 20 and 21. 20 protection in respect of certain offences and 21 right to life and personal liberty. Other than these two articles, all the other fundamental rights can be suspended by the President of India. Now, whether it applies only to the application of fundamental rights or suspension of fundamental rights, the answer is no. Here, during the operation of national emergency in total country or a part thereof, certain changes can be seen in the center-state relations. That is, extension of executive and legislative power. That is, the executive power of the union government will extend even to the state government. That is, the union executive can directly direct the state executive in the manner of its functioning, and also legislative power. That is, the parliament becomes authorized to make laws which are given in the state list under 7th schedule of the constitution. In ordinary circumstances, Parliament cannot make any kind of law on the state subject, whereas during the operation of national emergency, it authorizes the Parliament of India to make laws on the subjects which are mentioned under state list in 7th schedule of the constitution. Now, having seen the national emergency, which has wider repercussions throughout the country and wider repercussions on the fundamental rights of the citizens except 20 and 21, now we will look forward to the state emergency, which is popularly known as President's Rule. Now, President's Rule or state emergency is also known as constitutional emergency. It is also known as constitutional emergency, and it is specifically dealt under Article 356 of the Constitution. Now, we will see what are the intricacies pertaining to Article 356 of the Constitution of India. Now, state emergency. In national emergency, we have seen that there may be circumstances where only a part of India or the total India is threatened by war, external aggression or armed rebellion. But in this particular case, this will not happen. It happens when there is breakdown of constitutional machinery in the state. So, the state emergency can be imposed, or in popular words, President's Rule can be imposed in a particular state under Article 356 of the Constitution on the ground of failure of constitutional machinery in the state, or in other words, you can say breakdown of constitutional machinery in the states. So, what is meant by breakdown of constitutional machinery? Breakdown of constitutional machinery means where the state government is not performing its task in accordance with the procedures or formats as laid down under the Constitution. So, if the state government is not functioning in accordance with the constitutional mandate or constitutional norms, then it opens a ground for the governor to recommend to the President of India for the imposition of President's Rule. So, it happens when the state government acts beyond the Constitution or does not perform its constitutional obligations. So, the only ground is breakdown of constitutional machinery in the state. Remember, in certain cases, there is a debate that imposition of constitutional emergency where there is breakdown of law and order should be done. So, here we can say that breakdown of law and order cannot be considered as the breaking down of constitutional machinery. Why? Because breaking down of law and order situation is only one part, whereas when it comes to the failure of constitutional machinery, the entire constitutional functionaries in the state are violating the constitution in one or other terms. So, the failure of constitutional machinery is wider than the breakdown of law and order in the state. So, mere breakdown of law and order in a particular state doesn't mean that it opens a ground for imposition of President's Rule or state emergency. Now, coming to the President, it will be proclaimed by the President. Now, President here will not act independently. President has to act upon the advice as given by the Council of Ministers. However, even the Union Council of Ministers also will not take unanimous action. It is the governor of the state who should recommend to the President of India that there are grounds whereby there is a breakdown of constitutional machinery in the state and it is prudent to impose the President's Rule. So, even though the proclamation is given by the president, it should be recommended by the governor of the concerned state. Now, once it has been placed before the parliament for its approval, it has to be placed before 2 months. Within 2 months, parliamentary approval should be given to the imposition of president's rule in a particular state. When it comes to national emergency, that proclamation of national emergency should be approved within a period of 1 month. Here it is a period of 2 months. So, duration. Once the president's rule has been imposed in a particular state, it can be extended. It continues for a period of 6 months, after which it can be extended from time to time. So, here what it says is, however, during extension, we should remember that the governor should also say, the Election Commission of India should also say that this particular aspect, that is the conduct of elections in the state, during certain circumstances, what happens is, when the government is dissolved and the state goes under the president's rule, the Election Commission in that particular situation should say that holding elections is not possible in this particular state in the near future. So, that is the case, you can extend the emergency. But in all other cases, it can be extended beyond the period of 6 months. So, approval should be there from the parliament so that it can be extended beyond the period of 6 months. However, when we see that the state emergency gives more power to the federal government, that is the union government, over the states, and there have been n number of instances or many instances where we have seen that the union government has been misusing the power of imposition of president's rule in the different states. So, majority of the reasons are politically motivated. If we see the effects are very drastic. The state government is dissolved. So, the state government is dissolved and the state legislature is kept under suspended animation. That is, the members of legislative assemblies will remain the members, but they will not have any kind of powers. So, during the continuation of state emergency under Article 356, we will see that the state government is dissolved. So, the entire control over the state government, the executive control over the state government is exercised by the president through the governor. So, president assumes the function of the state government. So, president will have exclusive authority over the concerned state government. However, since the president of India is not so easily available to discharge the functions of the state government, so he will be discharging it through the governor, who will get delegated powers from the president of India, and president acts through the governor. So, in this particular situation, maybe this is the situation whereby many constitutional experts say that the governor acts as the agent of the union government, where the governor acts as the agent of the union government. So, here we will see that upon the recommendation of the governor, the president will impose the state emergency under Article 356, and it has to be placed before the parliament for approval within the period of 2 months, and once it is approved, it will continue for a period of 6 months at a time. So, here the entire executive power of the state government will go into the hands of the president of India, who will be exercising the same through the governor of that particular concerned state. Now, however, whenever we speak about this concept of state emergency, as we have already seen that it has been mistook, or it has been misinterpreted and misused many times. So, during the framing of the constitution itself, the framers of the constitution wanted this particular topic, that is the state emergency, the provisions pertaining to the state emergency, to remain a dead letter. That is, it has to be used only under exceptional circumstances. But the imposition of state emergency has been, on the contrary, more lively part of the constitution, where we have seen more than 100 times this provision was used to dissolve the state governments or to take control over the state governments. So, the dynamics gets disturbed even more. That is the equilibrium, that is the balance between the center and state relations get more disastrous, or you can say that is the extreme word, but more disastrous during the state emergency which has been imposed under Article 356. Now, this takes us to the next kind of emergency which is given under the Constitution, that is financial emergency. In the first instance, under Article 352, we have seen that the Constitution empowers the President of India to impose national emergency on the grounds of war, external aggression or armed rebellion. Under 356, it gives the power to the President of India to impose the President's rule in a particular state on the account of failure of constitutional machinery or breakdown of constitutional machinery. These two circumstances speak about the technical aspects. Now, coming to the financial aspects, the financial emergency is dealt by the Constitution of India under Article 360. Article 360 says that the President may by proclamation impose financial emergency in the country when there is a threat to financial stability or credit. The single ground which is given under financial emergency is where there is a threat to financial stability or credit of India. So, we have seen that the trade in the developing democracies like India is highly volatile. So, due to crisis of balance of payments and where there are more imports than the exports and where the Indian rupee gets weak, it may so happen that there may be some sort of financial instability in the nature. Not that it has happened till now, but due to the extreme financial instability or volatile situation where there is a threat to the financial stability or credit of India, then the President may proclaim financial emergency in the nation. The procedure as prescribed under Article 360 says that the proclamation must be given by the President of India, and once it gets the parliamentary approval within 2 months, it can continue indefinitely. So, here also the proclamation will be done by the President of India, who will do so upon the advice as given by the Council of Ministers, and the parliamentary approval within 2 months. So, once it has been proclaimed, it has to be placed before the Parliament within a period of 2 months, and once it has been approved by the Parliament, then it continues for an indefinite period. Why? Because you cannot say that the financial instability will cease within 1 month, 2 months or 6 months, since financial insecurities or uncertainties are there for the nation. So, in that particular situation, once it has been approved by the Parliament, technically it continues for an indefinite period, after which it can be revoked. So, there is a single ground, that is threat to the financial stability or credit of India. Now, we will see what will happen when the financial emergency has been imposed under Article 360. The effect of financial emergency, imposition of financial emergency, is reduction of salaries and allowances. In the normal circumstances, the salaries of all the functionaries which are charged on the consolidated fund of India or consolidated fund of state cannot be reduced to their disadvantage. Now, when there is a greater interest of the nation is involved and the finances of the nation is involved, it becomes necessary to maintain some sort of financial austerity or the reduction of expenses of the state. So, in that particular spirit, the reduction of salaries and allowances can be done. And now here, the financial autonomy of the state is totally taken away, and it is the union government which will direct how the fund of the state has to be utilized or how the fund of the state has to be used. So, the complete control over the financial matters of the states will be taken over by the union government. So, here in this particular circumstances, what will happen is the government will try to follow some strict austerity measures, that is strict measures to control its expenses, not to make extravagant expenses or unnecessary expenses, to control the situation. So, under this particular ground, even the salaries of all the constitutional functionaries which are charged on the consolidated fund of India and state can be reduced. The salaries and allowances can be reduced. So, this is the total effect of the financial emergency under Article 360. Now, if we see effect and consequences of emergencies, they are drastic. The first and foremost effect is centralization of power. Now, when we speak about centralization of power, what will happen is the different state units etc. they cannot act as an autonomous units, and they will be subject to the direct control by the union government. Next one is the curtailment of fundamental rights. During the existence or imposition of national emergency under Article 352, here we will see that fundamental rights except 20 and 21 can be suspended by the President of India, and the judiciary and judicial review. Under the garb of national emergency or President's rule, sometimes we have seen that misuse of powers have been done by the central government. So, in that particular situations, we have seen that judicial review by the Supreme Court of India has played a very crucial role in ensuring that the fundamental rights of the citizens are not deprived under the garb of emergency. So, emergency provides one of the drastic powers in the hands of the union government to take control over the state governments as well as the entire finances of India. So, even though this particular provision has to be used sparingly, these provisions, more particularly, national emergency was used only twice. Financial emergency was used never. Now, when it comes to the imposition of President's rule, it had been done more than 100 times. So, here we can see that the most contentious area of emergencies is the imposition of President's rule in the states, where there is under the ground of failure of constitutional machinery, which is a very wider ground. So, in conclusion, we would like to say that imposition of emergency centralizes the entire power structure in India, and the distribution of powers between center and state, which happens in the normal constitutional circumstances, is not continued, and it leads to a peculiar situation where the Indian federal government acts as a unitary government, as a unitary state. So, emergency is the area under the constitution whereby we can see that there is a strong centralizing tendency, whereby the entire parts, the financial, the administrative, the executive, all the parts will be vested with the union government. So, this is one of the areas which acts as one of the exceptions to the strict federal structure of the Indian Constitution.